may be referring to this recording later. I am State Representative Kristen Bonner, and I would like to call the meeting of the Work Group on Common Interest Communities and Homeowners Association to order. With that, we will dive right in. As we pass the minutes, I just want to welcome everyone back for yet another meeting. This is meeting 3 of the work group. And I will just restate our purpose to make sure we level set for all of those in the room. The purpose of the work group is to study the prevalence and impact of CICs, or common interest communities, and HOAs, homeowners associations in Minnesota, and how the existing laws regulating CICs and HOAs help homeowners and tenants access safe and affordable housing. And that is covered under Minnesota statute under Chapter 127, Article 15, Section 48 for the legal aficionados in the room. A quick note before we begin. We do want to have a reminder to our presenters and working group members that I understand that this is an incredibly passionate topic and for many a very long-standing issue. So I just want to remind everyone that we always want to treat each of our members and our testifiers with the utmost dignity, respect, and decorum, to be polite to each of us. And then I also want to draw to your attention in the packet today, there is an article from the Reformer. It does cite one of our members here in that article. The HOA files for the Otsego community that speaks to some roofing repairs. So certainly that is something for members to take a look at. I do, however, want to be very clear on level setting one additional piece that, of course, any member of this community should always feel free to share your perspectives and your expertise. But I just want to also be clear that if you're being asked to speak on behalf of the working group, that I ask that you please direct any press inquiries or individuals to the chair and to staff to make sure that we have a uniform official response from the working group. But again, please feel free to share your personal experiences as readily as you would like. And then for future public testimony, there will be opportunities for public input. If you're interested in testifying to the group, please email andrew.george@lccmn.gov. Again, that's andrew.george@lccmn.gov. No later than 3 days before the scheduled meeting. Please note testimony may be limited to ensure that all individuals have time for other items on our agenda. We would invite you to submit a written version of your remarks in advance, which can be longer than the short version you give to us. But please ensure you are subscribed to the working group listserv found on the working group website to receive notifications about future meetings and opportunities to provide public testimony. And I would love to make sure that in case you need a link to that, please, again, make sure to reach out to Andrew and we can get that link to you so you have it readily available. And with that, I am going to turn over to Dr. Klein to walk through today's agenda.
Thank you, Representative Bonner. Andrew is going to bring up the agenda on the screen for anyone who is attending online. Our agenda for today will begin with 2 presentations. Last week, we heard from presenters on the history of homeowners associations, common interest communities, and the laws behind them. This week, we will hear consumer perspectives from 2 presenters. We will have 15 minutes to speak. Please hold your questions until the end unless you need clarification. And then after both presenters speak, we will have 15 minutes for members to ask questions and get answers from the speakers. Following this, we will also have 2 community members presenting. And again, they will each present, followed by a Q&A and also time for member discussion of work group matters as a whole. and we will wrap up with some next steps before we adjourn.
Thank you for that. With that, our first speaker for today is Ron Elwood, who is the supervising attorney at for Legal Services Advocacy Group and Mid-Minnesota Legal Aid. Mr. Elwood, you want to come take a seat? Or I should say step up to the podium, whichever you prefer.
I think I'll sit at the table.
We appreciate that, that's valid. All right, and with that, I'm going to turn it over to you. And if you could please state again your name and your affiliation for the record, and then go ahead and proceed with your presentation.
Thank you, Madam Chair. Ron Elwood, I'm supervising attorney with the Legal Services Advocacy Project, which is Legal Aid's lobbying unit. Been with the organization for 26 years and been up at the Capitol and speaking with legislators and staff on issues that affect our clients, which are low-income Minnesotans, Minnesotans with disabilities, and elder Minnesotans. For those of you who don't know, Legal Aid provides free civil legal services to folks around the state on matters regarding housing and a whole set of legal issues. We're sort of the civil counterparts of the public defenders. And so if you can't afford an attorney and you have a legal matter that's affecting your health, safety, housing, security, economic security, those are the kinds of issues that we deal with. And my group goes to the Capitol on public policy matters. And I work with many folks around this room and always appreciate the opportunity to engage in these policy discussions. Thanks for inviting me to present today. I've been engaged in this issue for many years at the Capitol. We have had numerous clients that have had concerns and problems in their housing situations and HOAs, and work with a variety of the other organizations that represent homeowners, and also the Community Association Institute work with representatives of that organization as well. So just a quick overview. I think maybe some of these statistics are known, but just I think it's a good refresher. From various sources, I have the sources, I won't quote them. If you want to see them, I can show them later, but about 27% of Minnesotans live in HOAs, and that's more than 1.5 million each. That's a lot. Our understanding is there's national numbers, but I don't know how, and maybe CII can tell me if that's accurate. About 30 to 40% are self-managed in nationally, and I don't know if that reflects Minnesotans. Seeing Mr. Zatsky say yes, that's about right. And I know you had a presentation on the statutes last time, but just to refresh, these governing laws, 515, Chapter 515B of the statutes, were enacted 30 years ago, 1993. They have been amended periodically over time, but the powers to assess attorney's fees and the granting of a lien by the operation of law and the power to foreclose on that lien was there from the very beginning. I think another stark and telling statistic is that 82%, a little over 82% of new homes sold in 2023 were part of an HOA community. That to me was absolutely, I was blown away by that number. That's a lot. That's a tremendously high percentage of new construction where folks have required to be part of an HOA. So like everything, I think there are two sides to the story. I think we wouldn't be here if legislators all over the state were not hearing from constituents about dissatisfaction with their HOAs and rules and fights with boards and stuff. But I think let's acknowledge that if you are living in a common interest community, each household really needs to pay their dues, because to the extent they don't, then other folks have to subsidize them. And let's also acknowledge that board chairs and members are often volunteers who take on a very large, thankless, and unpaid responsibility for the operation of the entire HOA. Let's also acknowledge that all residents are not angels. We're trying to deal with some difficult people sometimes, and residents, whether it be volunteers or professional management companies, can sometimes be challenging. And let's also acknowledge that some residents simply flaunt the rules. And we've heard stories from our colleagues from the representing HOAs that people sometimes just ignore rules and then get angry when they're held to account. And that the rules of the HOAs are really intended to preserve the property values for everybody. With that, however, I think we should also acknowledge that, you know, there's a common response that we've heard when folks say, you know, well, this rule is stupid, or we don't like this, or we're being treated unfairly. And the common response we've heard is, well, if you don't want to follow the rules, don't live in an HOA. Basic, you know, hey, if you don't like it, then don't live here. That's a hard response to justify when 82% of new homes are HOAs. So there's the issue of choice, the response of, hey, you have a choice. Well, not so much anymore. Maybe that was 2 years ago, but as the HOA requirements and the developments have just exploded, and you don't have a choice. So I think we can somehow, I think we can at this point discount that response of, well, if you don't like it, don't live here, because I think we have to now address, and this is what this work group is tasked to do, is address perhaps some changes given that reality. I think, though, to take it up 50,000 feet, to me, the overriding issue is, as I see it, is something that the New Jersey Appellate Court described in a case. And they called it the broad power, that the broad power to levy fines is a governmental power. So where one law review article I read termed HOAs as private governments, and they say that serve to deprive the homeowner of certain liberties traditionally possessed by property owners. Another law review article notes that the statutes give a small group of people nearly unlimited power to impose whatever restrictions that they deem necessary. And another law review article suggests that HOAs enforce rules that would otherwise be clear constitutional violations if committed by a state agency. And I don't know, some folks may have seen John Oliver's piece on HOAs. And of course, you know, while it's satirical and he's a comedian and exaggerates things, but I think one statement that was in that I think really sums up what the point I'm trying to make is that, you know, HOAs can have the authority of a government, collect fees and fines like one, but when it comes to accountability, they can actively resist it in ways that government officials can only dream of. Meaning that there's this, so you know, in some, you've got essentially a quasi-governmental entity an entity acting as a governmental entity without any of the checks and balances that governments have. And yes, you can vote out the board, like you can vote out elected officials, and I'm not suggesting anything of that nature here with our colleagues, but you know, but nonetheless, it's a very different situation. But similar in the fact that you have governmental power essentially being assigned to people with little accountability. And I think it's the sweeping power and the perceived imbalance of or abuse of power alleged by some that have led us here today. And kind of unlike with a governmental situation, where if you're not happy, there's a place to go. You can complain to the agency if the agency is overseeing a particular industry and there's a problem. There's a place to go if you have a complaint and have that resolved. And in this situation, there's no place to go. There's absolutely no recourse anybody has because of the board that is imposing the rule or the fine or the assessment that the homeowner feels is unjust. There's really no place to appeal that other than back to the board, which imposed the fine in the first place. So I think, the other big picture issue for me is in an HOA, you've got sort of this real tension. And I think that's underlying some of these issues between sort of this personal freedom of choice and the need for uniformity across the HOA. And I don't know if you can legislate against that, but it is a tension that I think we need to acknowledge that I think underlies a lot of these problems. I mean, I want to put up the Minnesota flag, or I want to put up XYZ flag, or I want to put up an offensive flag, perhaps. Well, you can't do that. You can fly the American flag because the legislature mandated that a couple of years ago, but that's it. And so people can't, in many cases, exercise their personal choice and freedoms that they could if they lived in a private home. But on the other hand, there's an important need and rationale for some degree of uniformity. So let me just move to some of the areas that we've heard that, and I'm probably repeating things that everybody knows, but just to summarize, I think, the complaints and the horror stories you hear and the news articles and all this stuff, I think, it boils down to me to these sorts of issues that I think maybe if at the end of the day, if we can address those in this work group, it would be a tremendous advance. I think people just feel disrespected when they file a complaint. And worse, they wind up having to pay money to an attorney to get an answer for a question they raise or a dispute they have. I mean, that is one of the most rankling things. If you're asking a question, you're asking for documents, you get that, then you wind up with a bill from the attorney for $300 for answering your question. That seems ridiculous. And I think the other thing that we hear over and over and over again is these ticky-tacky violations and fines for things, grass is an eighth of an inch thing, the garbage pails are an inch over the line, things like that. The color of the swing set is whatever. So essentially rules that just defy common sense. And I think that we had a case recently, a complaint, so illustrative of this issue of the reasonableness of rules. We had a complaint from an elder Minnesotan, an elder couple, lived in an HOA, and the HOA imposed a new rule that required them to drag their garbage to a common spot somewhere in the complex. And these folks had difficulty, had mobility issues, and then of course in the winter in the ice, trying to drag your, pail down the wherever. And now, I mean, that's just an example, I think, of a rule that's just maybe not reasonable. There is a good rationale for it, clearly, because people probably, you don't want all these garbage pails along the thing that looks ugly, and you put it in one place, and maybe it's convenient for the waste management company. That makes sense. But yet, for those homeowners in those situations, or anybody with disability, perhaps, that doesn't make any sense. And there was sort of no alternative. It was A or B. That's it. You didn't have a choice. There wasn't an exception, that kind of. So I think what we can suggest is some areas for reform here. And what we would pose is perhaps reduce the scope of what HOAs can charge fees. And I know Senator Lucero had a bill last year, I believe, that had some of these suggestions capping or prohibiting fees for certain things. And I mean, I think that might make sense. I mean, let's look at, what is the scope and range of things that could be assessed, and how much are these fines? Are they commensurate with the offense? Because I think, one of the issues, of course, is it depends on the HOA, right? I mean, some HOAs are going to be very, they're going to be attentive to these kinds of things, and others aren't. But that's the problem, because there's, as said before, there's absolutely no oversight of any of this. And so only by statute, unless you, establish a state agency to oversee HOAs, which I'm not sure is feasible or even advisable, perhaps. But if you're not going to do that, well, then we need some common rules across the state, so that these outlying kinds of things, and I don't know the extent to which, we don't have any statistics. Part of the reason is because we have no oversight, but we have no idea. But we know, I mean, again, we would not be here if it was a handful of complaints about a few, outlying group HOAs. We just wouldn't be here. It's obviously gotten to a point where I think we need some more rationality in the statutes. We would also highly recommend prohibiting the charging of attorney's fees for certain things, like asking a question, getting an answer to a question, or asking for some documents, or asking for a breakdown of the itemization of things, or asking for the board answer, things that should not be accompanied by a $350, $400, whatever it is, attorney fee. That just seems ludicrous to us. I mean, there could be a statutory form letter or some of those kinds of things that could respond to some of these things, or not. But I think things are crying out for some reform in this area. And then this is a weedy thing, but if you're foreclosing outside of an HOA on a private home, Chapter 580 caps the attorney's fees and specifies and sets the attorney's fees that are available for that activity. Chapter 515B accepts HOAs from those caps. So it would seem to me that it would just be I mean, you're following the same procedure. A foreclosure in an HOA has to follow Chapter 580, just as it would if you were a private home and a lender foreclosing on the property. Why would the HOA be entitled to greater attorney's fees than an attorney foreclosing on a private home? That is illogical, makes no sense. And I know Senator Lucero's bill provided for a statutory time period to pay late fees, things like that. I think in terms of the rules, I think we would propose, or offer, I should say, that there be some sort of a reasonableness standard established. If you look at the statutes on manufactured home parks in 327C section, that's chapter 327C, there is a reasonableness. It's a similar situation. While they're not HOAs, it's a very similar, it's an analogous housing arrangement. There's a whole group of people in a community, and they share different things. The management of the manufactured home park takes care of common area kinds of things. It's a very analogous situation. And in that statute, there is a requirement that rules need to be reasonable. And then also simply the last thing I think we would talk about is some sort of a dispute resolution process. whether it be internal, certainly as we talked about earlier, there's a ombuds bill that's been out there, so we're someplace to go to try to get disputes resolved before they escalate. And I think those are the primary things that we've seen. And I'll stop here and again, want to express my appreciation. Thanks for inviting me to talk to the group today.
Thank you, Joe, but I appreciate that. That was a fairly comprehensive overview, and I appreciate that. And also some very good food for thought. I will then go in, just because I want to make sure that we preserve time for questions. We're going to skip straight on to the second presentation. And I'm sorry, I did not get instructions on how to properly say your last name. Is it Gugin? Gugin. All right, Ms. Gugin, please come on down and please state your name for the record as well as your affiliation, and then go ahead and go forward. I do want to remind members that if they do need a very specific clarification, that we can take those during presentations, but we do want to try to reserve questions until the end to make sure that we get through the material. All right.
Thank you, Representative.
Okay.
My name is Julie Gugin. For up until June of this year, I was the CEO and president of the Minnesota Homeownership Center. I held that role for just over 17 years. I'm retired now, so I don't represent the Homeownership Center, but I do bring a couple decades of experience with a range of homeowner issues. The Minnesota Homeownership Center's role in the homeownership spectrum is to support a network of community-based homeownership advisors or counselors who provide homeownership education and counseling to people who want to be homeowners, and also provide much needed crisis counseling in the case of foreclosures, or for today's purposes, issues related to HOAs. When I was leading that group, the topic of homeowner associations was frequent, and the recency phenomenon during COVID in particular, we saw many homeowners who were experiencing financial hardship and or other forms of hardship that really exacerbated their relationship with their HOA, and in fact caused many foreclosures that were particularly distressing during the pandemic. In my role at the Homeownership Center, I worked very closely with Ron over the years, and take much guidance from Ron on this subject. So I support most of what Ron had to say here. I think his legal experience, his legislative experience, and his experience with homeowners are all very compelling on this topic. The issues that our homeownership advisors experienced with homeowners, I think, can be categorized in basically three important areas: governance, debt collection, and accountability. So frequent concerns from homeowners about boards and or the property management companies with no communication about board meetings or improper communication about upcoming board meetings and meeting notices. Meeting minutes that weren't available to homeowner association membership. Egregious leadership on the part of a handful of folks who sometimes would control the entire association and hold that control very closely. And just in general, transparency with homeowners about how the association is being managed, who's managing it, and how they got that role. A couple of, in several examples, We heard from homeowners who basically said that there was no board of directors, that the property management company was serving in that role. So they're the hired board then, or what is their real? So just a lack of consistency, a lack of legal and ethical patterns of leadership brought frequent concerns. Debt collection. So when a homeowner association assesses whether it's the ongoing fees that are necessary to manage the business, or whether it's a special assessment, frequently we would hear from homeowners who were not notified, or there were inconsistent patterns of communication about who was notified and what they were notified about. So just very questionable practices among associations about their role as debt collectors and what they can or cannot do in those situations. Frequently inadequate justification for the amount of the fine. This gets at Ron's and Senator Lucero's concerns about reasonableness of fees. One of my favorite examples was during COVID, a homeowner was stuck outside the country. They couldn't get back for weeks and weeks and weeks. And by the time they got back, their garbage container had sat outside their house. And they owed $14,000 for that. $14,000. And they lost their house. I mean, they didn't have $14,000, they lost their house. That to me is, why is that happening? I don't understand. Another situation during COVID when throughout the country and across various types of mortgages and through many government entities, foreclosures were stayed. Mortgage foreclosures were not allowed during a period of COVID. And homeowner associations flew under that radar screen. Foreclosures were allowed and were rampant during COVID. One man that I spoke with time and time again was trying to save his home. He did not have a mortgage. But he was told by his association that the $5,000 assessment that he was never told about had now grown to $18,000. So a home that he has owned outright for over 20 years was foreclosed on during COVID. And he ended up losing that property and that asset because the homeowners associations could do things that mortgage companies could not. So debt collection, what's reasonable and what's ethical and legal in those situations, I think you have to take a very close look at. And then finally, the question of accountability. Perhaps Ron and I differ a little bit on this subject. I think there needs to be government oversight of homeowner associations. I should be able to go to the Secretary of State's office and pull a report that shows where all of them are and who the president is. I should see their annual financials, just as I had to file every year. As a nonprofit, associations should have to file that every year. So I do believe that there needs to be government oversight. There needs to be registration. As I've heard from city officials who say, I wish I knew where all the associations were in my city. There's no way of really knowing that. And I think that's a problem. I think that registration, that oversight, that accountability gets at the question of visibility of homeowner associations. I am thrilled that this group exists. I think it indicates that this issue has been latent for far too long. And the fact that we all are gathering raises this visibility. And I think we need to ride that wave and make sure that homeowner associations are visible, that the rules they follow are visible, and that we all know where to turn when there are issues. One final example, and I know there are case stories that we can all share, but the homeowner advisors who work with folks in foreclosure or any kind of homeownership crisis, they want to help. That's what they're there for. They don't charge. The services are free. But in order for them to help homeowners who live in associations, they need to contact the association, because the homeowner doesn't have the financials or doesn't have the record of the fees that they have paid, or their record shows something different from the association. Every time the homeownership advisor calls the association, it's referred many times, not always referred to an attorney, and that's a $400 fee to the homeowner who's just looking. So homeownership advisors' hands are tied because they want to support the homeowner, but if they do, the homeowner starts to owe more money. And Ron laid out that issue very clearly. It's impossible for homeownership advisors to do their job when the practice is every question is referred to. So I'll stop. Thank you, Representative.
Thank you, Ms. Gugin, for that presentation. And then next, we have some time allotted in the schedule to ask questions of our two speakers. If members have any questions, clarifications they'd like to see, Senator Ms.
I would like to see a clarification on the role of the board. I know it's been presented that they're only volunteers, but their purpose is to carry out the CCRs. And so why isn't whoever filed the articles of incorporation responsible for the conduct of the board? In our case, it is Centex. Centex is the builder who established the association, but Centex is nowhere to be found. But the board, their purpose is to carry out the CCR. So why are we voting for a board that doesn't represent us when their responsibility is for somebody else and somebody else is nowhere to be found? I would love to see the nature and the responsibility of the board being further defined and enrolled and have that accountability of having whoever filed the articles of incorporation, they're responsible for the conduct of the board, not dumping on the homeowners to help them figure it out. Because we're voting for people who don't represent us. Let's get real about it. Their purpose is to serve the purpose of the CCRs, and the CCRs don't come from us. The CCRs come from whoever filed the articles of incorporation and from the municipality. So we need some further clarification on the nature of the definition of the relationship of the board. My thought is if Centex were to put in some business practices that made sense and required the board to function as their board would function, a lot of this would be, wouldn't even be an issue of their accountability. They just say to the board, make sure the grass isn't more than 2 inches tall, but they don't say file an annual report. Or if the board embezzles, the board needs to go to jail. They don't put in those kinds of business practices in their role. They just kind of do the dump and run. So I would love to see that part of that accountability piece of it, because also, let's get real, the law says that management companies are supposed to be a neutral third party. Well, they're not a neutral third party when they're the sole signer on our bank accounts, and they're telling the board what they can and can't do. So we need some more definition and clarification about the roles and responsibility for who does what and why.
Yeah, one quick moment. If you could, for members, especially because the general public may be watching, whenever you use an acronym, if you could at the very least, the first time, make sure that you spell out what that is. So that the public understands and we all have a level set. So for example, you use CCR, could you define that for us, Ms. Cole?
Yes, thank you. CCR is the contract covenant and restriction. That is the contract that the builder or the developer makes with the municipality in order to implement this development. It is a long list of rules and how the HOA would be implemented. For example, in our CCR, there is a thing in there where syntax says that homeowners cannot hold classes of religious instruction. Well, that's part of the agreement they made with the municipality when they put the contract in place. Thank you for asking for that.
All right, thank you, Ms. Cole. And Senator, did you have a quick question?
Quick question or more feedback. So thank you both for the testifiers. I appreciate those remarks. And as I was jotting notes down here as they're talking, and I think it's very valuable what they had. And for us as a group, as we continue to hear voices from across Minnesota, I think we need to just keep in mind as we're brainstorming ideas for recommendations as the product of this group. At least for me personally, I hate reinventing the wheel. There's no reason to reinvent the wheel. So as we see these things as from the testifiers and others, past and will be coming, just keep in mind or think about the other areas of our lives where statute already exists. There might already be things that are substantially similar that we can use to apply to what we want to do. So for example, I'm thinking the appeals process or dispute resolution that Mr. Elwood mentioned. You know, realtors, as a realtor, there's arbitration as an option. So that process is already defined and spelled out. Can we borrow from that rather than trying to brainstorm and come up with a new process? Might that be applicable? And in terms of, I think mobile home park was also mentioned in terms of some of the control delimitations. That's awesome. That's a great thing we could look at. Maybe borrow some stuff from there to implement here. Meeting minutes of the board and being available and be able to ask questions. You know, as a former city council member, you know, there's already a process defined for citizens to come in and be able to have an open mic session or be able to ask questions, and they're not charged these fees by lawyers. When it comes to the foreclosure process, that's already defined for other entities, banks, etc. So can we borrow more from that? And I love the idea of there should not be this foreclosure process that is limitations. I think that Mr. Elwood had mentioned the lawyer's fees. I forget who said that, but yeah, that whatever is applicable there certainly would be applicable in foreclosure. And then when it comes to the registration of HOA boards, you know, I'm again putting on my realtor or general contractor hat. The Department of Labor or the Department of Commerce, they already have a database of contractors, their license number, their contact information, when they expire, et cetera, et cetera. And it's not that hard to be able to compile such a database. I'm not suggesting that either one of those departments may retain that database, but it's not that hard to put something together to borrow that idea or that concept. Then last, I guess the question for the testifier, Madam Chair, would be, in the case you gave an egregious example of, or several of people losing their homes to foreclosure, what happened to the equity? Did that equity go to the homeowner or was it retained by the HOA?
I don't know the answer to that, Senator. That's a good question. You know, they presumably they lose their equity. They no longer have title to the property.
Well, it depends. I mean, I think the recent Tyler decision speaks to that. The Tyler v. Hennepin County, where the Hennepin County sold the home based on it's a tax forfeiture. That was a tax forfeiture situation. But, you know, if there's whoever purchases the home purchases it at the sale price, right? So if the sale price is less than the equity, then the homeowner would get the equity. If the sale price is equal to or, you know, less than what the equity is, then the homeowner would lose the equity.
And so my concern would be, Madam Chair, is in the case of an HOA doing that, it's a private entity doing it rather than the Tyler decision. It was, at least my understanding, non-lawyer is, it was a violation of the takings clause.
Right.
And so can a private company be subjected to, or private entity?
No, no, but the concept is if you're, the sale price, somebody bids the sale price. So the sale depends on, if the sale price is, if there's equity left, then the homeowner gets it. That's under foreclosure law.
So if that's not explicitly spelled out, I think.
Well, the thing is that the homeowner associations foreclosing on a lien have to follow our foreclosure laws. They already, all of those statutes that apply in mortgage foreclosures apply in HOA foreclosures. So you don't really need to do anything because that's already there. We already use our existing process.
But if there's equity, if statute doesn't explicitly define that, that needs to go.
Well, there is a surplus. If there's a surplus, it goes.
That is defined. Okay.
Yes.
Is there a requirement, last question, Madam Chair, is there a requirement that the HOA, if they do foreclose, that they sell? Can they keep it and potentially rent it out, or?
That I don't know.
Yeah, they are the owner of record.
Sometimes, yes, but many times, I would like to be clear, many times they're subject to a first mortgage. HOAs do not, in my experience, want to be in the business of owning rental property. Some of them do, there are exceptions. However, many of them are subject to the first mortgage and they're really waiting for the mortgage company to foreclose so they can take them off of their hands. And many times in those situations, they lose out on many months of dues because the way the law works, the mortgage company is only required to pay the back dues from the date that they did their share of sale, I believe. So during their 6-month redemption period, they begin paying dues. Keep in mind, there's dues that are owed and that the other homeowners who have been paying their dues are responsible for offsetting that lost revenue.
I just want to make a comment and think about what you just said. Go. Well, I respect the idea that the association may lose out on dues for a number of months. I think we should also be sensitive to the fact that someone may have lost more than a few $1,000s worth of dues, perhaps their entire life savings, their entire way of life. In some cases, such as the one cited here, for very little reason. And had they retained that property and not been assessed some pretty egregious fees, they would very likely still be paying their monthly dues and would still be paying into the association. So I just want to bring us into that and make sure we're sensitive to that.
May I provide additional commentary on that?
Sure.
So in most cases, when professional management is involved, we would never advise to foreclose in a situation like that. I don't know that particular case, but we would also never advise for those types of fees. It would be the position of CAI as well to provide advice to anybody to never do that. Those are egregious fees and those should not be allowed. And I believe that we should take action regarding those. What I'm speaking of are particularly the monthly dues that are required in order for the association to be maintained properly for the other homeowners. Yes, fees, that would be one of my recommendations if I ever have the opportunity to speak as well. As far as testifying goes, that would be a recommendation of mine as well. Would be egregious fees should not be allowed, and you certainly should not be able to foreclose on those fees.
One other, just on that point, if I'll take a point of personal privilege, I think one of the things that I have not seen a lot of associations employ, but I wish that they would, is that if for some reason the homeowner is unable to be reached around a specific issue, that they may offer the possibility or that the association could ask if there is an alternate contact for that individual. To help with dispute resolution, to help with questions. If, say, they are not getting a response on something. I know that I personally worked in unison with my brother who had an association, and we repeatedly had to ask to have the association go through me as a proxy for him. He gave them his permission, he gave them it in written consent, and yet we still had continuous challenges every time the association went through me, I made sure that all of the issues were addressed in a timely manner and handled quickly. Because I could get better access to my brother who owned his own business and often wasn't available for questions when they needed those answers in a timely fashion, but I could do so for them. So I think that having some sort of a fail-safe in that sense also would also be beneficial to both the associations and the homeowners. And I would love to see that incorporated in legislation to make sure that that is also a route. Because there are some homeowners who may be listed as the person of record who may not always be able to respond in the timely fashion that the association needs, but there may be someone else that would be willing to be a proxy on their behalf to do this. With that, Ms. Greedy, you had a
Yes, I just had a quick question for Ms. Judy. So for the clients that come in for counseling that are having issues with their association dues, you said that there was a $400 fee. Is that for the counselor to make the inquiry, or are you seeing cases where a management company or board is charging an owner just to see their own financial documents?
Yeah, I throw the number 400 around because it's a rate that we commonly see. That's a, for example, attorney fee. So one example, a homeownership advisor talks to, let's say it's the board chair or somebody who represents the association. And the board chair says, well, to get that information, to get our accounts, to get a financial statement, to get a history of what we have for what the homeowner has paid, you have to talk to our attorneys. They perhaps are a self-managed association. They don't have a property management company, and the board members don't deal with any of those kinds of questions. They refer everything to an attorney. Many associations have a property management company, and sometimes that's very easy. The advisor can call the property management company. Property management company will get them what they need. In the best case scenario, they're not charged for that. In the worst case scenario, there is nobody to provide that information except an attorney, and that's when the charges are incurred.
Okay, even to an owner.
We will allow you to do that just for one brief moment. Let's finish this commentary and then I will be happy to go to. All right, Mr. Elwood, if you would like to chat, go ahead.
Yeah, I mean, I just want to echo what Julie said, because Colleen is on vacation. She can't be here today, our legal aid member. But this is a common problem that she has seen. It's exactly the same thing. So folks, not only homeowner advisors from the Homeownership Center, but also legal aid attorneys are reluctant. They have to tell clients, look, I really want to help you. But if I am referred to the attorney, it's, so it's this rock in a hard place. And we're almost dissuading our own clients from getting our help because it's going to cost them more money to, once our attorney writes a letter to whether it's the management company or the board, it's always referred to the attorney, and then the attorney's fees come. So that is something we really, really, really ought to address in this in work group. So I just want to spot on.
Don't go there.
Thank you.
Don't go away.
Yeah, so if you would, Mr. Elwood, stay. And we do have a question from the audience. I will go ahead and entertain that.
Okay, so I'm a homeowner and you would ask the question about getting your documents, what that costs. So we were, I should preface actually, we haven't had the homeowners association, but it's been there for the state out of communities because of costs. In the subdivision agreement, it does say that it has to be provided before they ever develop it. We ended up with a board group of developers. They came in and actually elected themselves. These are homeowner signatures and affidavits. And they're a two-person board, 15 years. But they're telling us that we have to pay dues, so we're asking them for documents. We spend a year and a half with attorneys trying to make documents and $1,000. First Service Residential is the management company. Actually, guy that came from Oregon is one of the developers is actually employed by First Service. And they come in and they tell us that it's all portal. A lot of us residents, you know, are hesitant to sign up to this portal. It looks like a contract. And I was told by the Attorney General's office that it's buyer beware, didn't sign up. I talked to a couple neighbors who did, who blocked us into the portal. None of these documents existed. There was no meeting minutes, there was no agenda to any meetings, there was missing information for people that couldn't attend the meeting. They weren't providing any notice to these meetings, which is how they formed 2 versus 4 to 15 information. In total, we ended up paying for service $450. And they had actually promised us that they had election records, right? So we agreed to pay that $450. Our attorney spent 3.5 months trying to obtain these records. We got them beginning of October. And it in total cost us what, $7,000 if we ever got any election records because it didn't exist. They weren't. So we're definitely thinking that the law is lacking criminal accountability. We have a very significant issue here. We have couple corruption, and this is actually a great account for it. Laws currently don't have any criminal repercussions, and they allow these people to come in here and try to force homeowners out to live there, and already lost, you know, all the promised amenities, which are still actually technically promises. There is no expiration on them. And basically bully us, and they get a high behind insurance. We'll pay tens of thousands of dollars to fight this, and it's not even legal. And our attorney recently withdrew. We have depositions which we don't even know and we found out he didn't file answers. We didn't depose them like he said. He withdrew and basically just told us that it's all here. And I think you're excited.
Yeah, thank you for that perspective. I will say, I broke protocol. We generally don't take public testimony in the midst. But I would like, if you could, but I thought it was timely in this moment, so we broke protocol for that. There is time at the end of the agenda for additional public testimony, just to be clear on that. And I do want to make sure we do have 2 presenters here today that we want to get time for. And if you could, before we move on, would you be so kind as to supply your name and if you have any affiliation with an organization for the record?
Yes, my name is Joni Erickson, and I do not have any affiliation.
And what city are you from, Joni?
I'm from St. Cloud, Minnesota. It's the Homeowners Association of Deepwater Sedge at Donovan.
I appreciate that, Joni, and I appreciate the insight. With that, I think Senator Lucero has one additional question that we want to get to. And then what I'd like to do, if there are no other questions for these presenters, oh, I'm sorry, and we have one online, and then, oh, okay, all right. Well, we have a couple quick ones, and then I want to make sure, though, we are thoughtful about time because I do have some folks here to present that we want to get to as well. Senator, do you want to go last? Or?
I can go last, but I've already.
All right. Why don't we go to our friend online, Ms. Taylor, if you'd like to go ahead and proceed, and then you will come here in the room to Ms. Bergen.
Hi, this is Ivory Taylor. I want to just uplift what the homeowner in the audience is speaking of. I also experienced as a homeowner trying to retrieve documents about our contracts and the money that was being spent at our condo because we kept getting egregious fee increases with really not any explanation, and most of the folks at my building were not looking into what was going on. They were kind of just blindly believing what was happening. So I started looking into what was going on. and asking Associa, which is our property management company, for those documents. I'm well versed in the law, and I know that it is my right to receive those documents. And shared those statutes with Associa as well. And so doing so, I spent months and months and months going back and forth with Associa, clarifying my request, putting it in formal writing, sharing statutes, being told we're getting the documents together. They're almost ready. They're coming to you. We've got them coming. You're getting your documents soon. I have never received those documents. It's been over a year. And the law has been violated. I have no recourse for it unless I get an attorney. CAI advised our board that they needed to get an attorney, and then of course provided them with a handy list of CAI attorneys that they could hire. And so I know that if I were to engage in getting an attorney, I would start getting assessed for the $450 an hour attorney that they hired to address my issues. So I haven't done that. So the thing that I want to talk about is Attorney General having the ability to implement and enforce the laws, even the ones that exist. When they are being broken, I think is very important. Obviously, there's a private right of action, but because we are forced to pay for the association and the board or the property management's illegal actions, people aren't really given the latitude to enforce that private right of action, as our legal aid colleagues have talked about today. And so, yeah, these are some of the many areas where there needs to be reform. So I just kind of wanted to bring that up, and thank you for the time.
Thank you.
I have a question or a comment. I'm sorry, Madam Chair. I've been trying to figure out how to raise my hand. For some reason, my icon is not working today, so I apologize to have to just interrupt.
That's okay. I do
Yeah.
want to just level set and remind members of the public do have a period for comment at the end of the presentations. So
I'm not a member of the public. I'm a member of the working
I
group.
know you are not, Ms.
Yeah.
Butler. Just want to remind the public in the room.
Okay.
Member Butler, if you.
Yes. So we've talked about foreclosure, the traumas and the harm, and nobody's talked about what other methods can we put in place beside and remove the foreclosure option to HOAs, because it has done more harm than good. The idea that HOAs are taking people's home, their wealth, their ability to create wealth, or their wealth that they have created over years for $14,000, $15,000 is ridiculous. Purchasing a home is not cheap. $200,000, $300,000 loan for a home should not have the option for a HO company to be. It never should have been put in place, and it needs to be removed. They should not be foreclosing. There are other recourses that are available for capturing fees. Leveraging putting levy on people's income is, options are available for credit card companies who people owe way more money than they owe for HOAs. So this idea that we need to have this foreclosure in place for the HOAs to be made whole when fees are lost or accumulated by a homeowner is ridiculous. And I would like for this group to put something in place that removes that, and they leverage that, right? They use that to bully the homeowners because they know that ability is there, that option to foreclose on people's home for the least amount of dollars. There's not even a minimum or maximum somebody should owe. $2,000, whatever amount the HOA can decide they're going to foreclose on a home. And so we should look for another way, another recourse for HOAs to be able to capture their fees and be made whole. And foreclosure should not be an option.
I agree. I think there's been an underlying thread here about resolution and what that looks like, how that could be done in a more efficient and effective manner so that everyone wins. Certainly, we also want to make sure that HOAs get the fees that they are due so that they can pay for their maintenance and all the things that they need, but also be respectful of homeowners as well. So I appreciate that, Member Butler. And then in the room here, Ms. Bergen, we'll go to you. Then close out with the senator and move on to our next presenter. Ms. Bergen.
Thanks. I'll just say, I think this is a great list. as someone that works for cities and has encountered a lot of issues over the last 20 years with housing, this captures almost everything, but what I'm not seeing that neither of the speakers brought up so far is capital improvement planning and making sure that homeowners are setting associations, they're setting up the associations to be able to cover future expenses that properties can be maintained or that they have qualified against. So I'm wondering if there's thoughts that either of you wanted to share on that topic.
I don't fully understand the implications, but yes, if I'm buying in an association, I sure would want to know that my association is solvent now and will be solvent into the future when the property needs additional maintenance. I think the counter to that is what some associations do is they don't budget for long-term reserves. They just assess when things come up, like a roof or I don't know, some shared plumbing issues or whatever, that they just use the power of assessment as opposed to the power of long-range planning. So it's a good point.
Are you suggesting about maintenance and repair kind of reserves, or are you like capital improvements, like additions to I wasn't clear.
Yeah, I mean, more like me. Oh, thank you.
Just a reminder to go through the chair.
It would be more just maintaining what is in place, rules. The reason people are getting acceptance is that the associations aren't planning for future needs of facilities. That's what we observe. That's when the city's getting involved, when there's extreme different maintenance. And we know Minnesota isn't like Florida. Florida has these massive issues with space. Reading some articles about what's happening there. I think it's something to be talking about an interesting, but I was just curious if, just because it's kind of not on here. It's the only thing that I'm aware of, after watching all of these things happen in associations, that's not on the list.
And I will just say for clarification that I believe that topic may fall under one of our future meetings. But I appreciate you bringing that forward. And I believe we did outline that in one of the future topics as being included in that conversation. So more to come on that particular issue, but I appreciate you raising that up for us. With that, anything further before we head off to represent Senator Lucero?
Thank you. I also appreciate that. Thank you for bringing that up. That's critically important for those costs that are known to have depreciation, that there will be costs versus the unexpected. Something that can certainly be planned for. But my question is also for the testifier. My last question would be, we heard from the woman back there, and I think one other he was touched on. If members in an association want to dissolve, what is that threshold, or is there a process? Are you aware if there's a process, or 80% or something like that to dissolve?
Senator and Madam Chair, I'm not aware of that. I don't.
I have the information on that.
Mr. Zavitsky, sorry. If you'd like to go ahead.
Thank you, Madam Chair. There is a process, but in my opinion, and I'm not sure, but in my opinion, it is too stringent. I first of all would like to thank both presenters. I think all of your recommendations are very reasonable and should be implemented, most of them. As far as dissolving go, that's the other problem that we see is there's not enough variety of homes, and that was discussed. 85% are built in HOAs, and that's because municipalities are requiring it. If you talk to builders and you talk to homeowners, the builders don't even want to build an HOA, but they're required to by the city. And the single family homes that we take over, that is one of them that we were asked to take over. They don't want to be in an HOA. We're just simply the management company. I'm putting my first service hat on. The builder has hired us to be the management company, and really for that association, mostly what we do is collect dues and process the financials only. But I know they don't want to be in an HOA. For them to get out of it, it is the city is requiring it. So it's not even the builder in that case, because the city was requiring if the builder took over that development, it needed to be an HOA. So everyone's stuck, and it's very unfair to a lot of homeowners. Many homeowners, I have personal friends who paid way overpriced for a lot in Maple Grove because they did not want to live in an HOA. So they paid this astronomical fee to buy a single lot that wasn't in an HOA. They don't want to be an HOA, but everything in Maple Grove that was being developed is in an HOA. So there does need to be more diversity, and people need to be able to just all without 100% is typically the requirement.
Thank you for that, Senator Lucero.
So thank you for that. And so just to clarify, that threshold you just referenced, 100%, is
Typically
that,
around 100%.
is it defined in statute or is it defined on?
Governing documents.
Okay.
Yes. And it should not be 100%. Because we can't get 100% of anything. I mean,
We are legislators. We understand that 100%, well, admirable is probably not a reasonable standard. For that.
That's all I have. Thank you.
Oh, okay. All right. With that, I am going to push us into the next phase of the evaluation. I want to try to keep us on track here. We have, our next presenter will be Ms. Djordan, who is coming up to speak for us. All right. And Mr. Djordan. All right, very good. If you want to go ahead again and state your name for the record, your affiliation, and in this case as a homeowner, if you wanted to specify which homeowners association you belong to. Yeah, thank you.
Good morning, Madam Chair, Vice Chair, and members of the working group. Thank you very much. My name is Jennifer Djordan. I'm a community member and a member of an HOA. I'm joined here with my husband, Todd, as well. And thank you very much for the opportunity to speak to you today. Our family lives in a single family homeowners association. And I'm speaking today about my experience living in an HOA and asking this working group to recommend reforms to protect the 1.56 million Minnesotans that live in the 7,950 associations, which comprises 620,000 homes in associations across Minnesota. Associations are big business when looked as a class. Nationwide associations collect $108.8 billion from homeowners and assessments every year and hold $27.2 billion in reserve funds for the things that you asked about. It's no secret that HOAs have become troublesome. HOAs are run by residents with no training, no licensure, who may not be familiar with the complex laws around HOAs and the responsibilities, and may not even have a complete understanding of their own governing documents and the responsibilities to use the powers granted to them by the state judiciously. Current HOA laws are complex and covered under multiple state statutes, 515B and 317A. Homeowners are at a significant disadvantage because boards, attorneys, and management companies pick and choose what they want to follow or ignore the requirements in their entirety. As a result, the homeowners are stuck in an endless maze in their darkest hour. Most homeowners have no assistance to navigate a complex maze and nowhere to go to seek refuge other than ask the courts for help. But the truth is, courts are very uninterested in being tasked with being an HOA nanny because HOA disputes are better suited for a different type of resolution where long-term solutions can be found. Management companies that run these HOAs for these elected boards have no licensure requirement, are not held to accountable for mistakes. There's no regulatory body in Minnesota to discourage and prevent abuses. And as you can see by the news, there are some. Management companies know very well that homeowners have little recourse against the management company or the board gone rogue. So there's little incentive to resolve conflicts in an amicable manner. Attorneys used by these boards as collection agents or to pursue actions against homeowners are also not held accountable for mistakes or abuse because they know their legal fees will be paid either by the homeowner or the board's insurance company, creating an environment that is hostile to settlement or quick resolution. They know that they have a war chest to wait a homeowner out because the homeowner will give up, move, or lose their home to foreclosure. Homeowners are also not told at the onset that communicating with the board's attorney will likely lead to charges placed on their account, and they will have limited recourse to object to unreasonable charges and fines. There are many examples, as you've heard today, and also that I could provide, but I'll start with my own and my husband's. My HOA is an example of a situation where homeowners should never have been faced with. The trouble started in our association when the elected board stopped having elections, refused to have open meetings, lacked transparency in operations, and their financial and corporate records were carelessly maintained, if at all. We had concerns about the lack of elections, operations, accounting practices, and we decided to withhold our dues until the association restored elections and followed best practice. In October of 2019, thousands of dollars were demanded from our family. To protect our home, we paid $4,000 to remove the lien that was put on our home under duress. My husband and I immediately brought litigation against the association in district court, plus a second action in conciliation as pro se litigants. Our homeowners association, however, had 2 law firms, 5 lawyers, multiple paralegals and legal assistants, and an infinite amount of money through insurance policies and their ability to levy all homeowners to fight us. Our family had ourselves, and the board had a fully funded legal army to refuse to provide the official documents and overpayments that we made to protect our home. We discovered under discovery, which we did ourselves, I got some advice for you, that we were charged usury-like level interest rates that different homeowners charge was placed on our account, and other unrelated charges were put on our account wrongly. In the end, through a mutually agreed upon settlement, our association paid us $5,000 out of association funds and $10,000 out of insurance funds through the wrongful acts policy, plus all mediation costs, and agreed to long-term operational changes such as hiring a management company. We ended up recovering almost 4 times what they forced us to pay. Recently, and I mean very recently, like this month, our homeowner association fined me for asking a question related to a recent law change regarding the collection policy that the state legislature passed. I had concerns our policy did not comply with this new law. The management company, Gaston Management Company, asked me to provide additional information. I did at the next open forum. The board objected to me providing this information and ultimately fined me $50 for speaking. There is no allegation I was rude or disrespectful or unprofessional, and there's a tape to prove this. I was fined because I spoke at an open forum portion of the meeting and the board did not like my speech. The fine was placed on my account and I was told if we did not pay it by a certain date, I would be assessed an unstated penalty. When I tried to pay the fine under duress, their attorney, Matthew Greenstein of Greenstein Sellers, threw my check on the floor in a public hallway and refused to accept it. That's unreasonable. I had to pay that fine because if I did not, guess what? They could have liened my home and I would be back at square one. The documents of this latest incident are attached in the exhibits I provided to this committee. Unreasonable fines, rule changes with no public feedback, bullying, questionable conduct, conflicts of interest are things that happen in associations across Minnesota. The scariest part of an association is, because we're in Halloween, I thought I'd tell a horror story, is that most people do not know that you can be current in your property taxes, you could be current in your mortgage, and your homeowners association or community interest could take your home if you're late and your dues or fines, even if it's just one single penny. And that's not true in many other states. Minnesota needs to join states like Texas, Colorado, Florida, and California that have reformed and modernized this section of law to provide a basic level of protections for homeowners and dignity. Reform is not burdensome, it is timely. This sector of real estate has grown exponentially, and Minnesota state laws have fallen behind. A Minnesota homeowners bill of rights is desperately needed and is just common sense. I provided you a few ideas that could be incorporated if the working group finds it wise. For example, provide a unified set of protections for homeowners in 515B or 317A. Elections, regularly scheduled elections, and a maximum number of terms a member can serve on a board of directors. Operations and education require board members to receive basic education or certified that they have read the law. Provide agendas and notices of meetings, open forums, reasonable time limits on dues increases, and if they do a special assessment, make sure it's reasonable or provide an alternate reasonable payment plan to offer to the impacted homeowner. Limits on the maximum amount of interest charged to a homeowner. A central database for homeowners association with the duty to report that annual report. Adequate notices to discuss rule changes. Regular financial disclosures and a duty to do a financial review by an independent body or an audit. Require associations to do bids, conflicts of interest, protect homeowners. Most importantly, a clear due process in dispute resolution or an alternate way to provide to deal with conflicts such as mediation or housing board or some others, but most importantly, an oversight or regulatory body that would provide a place for homeowners to report abuse of boards, management companies, or the attorneys that represent them, so that they can, and also to provide those with individual best practice or education. That is important. And revise the current law to allow corrective action to either be taken by the oversight body, omnibus person, or even the Attorney General's office. A level playing field for fairness and housing security is important. Families who live in these HOAs and common interest communities need this reform because their home is typically their largest single investment that they hold. And finally, I'd like to end this with where my story started. When I was 10, my mom, my sister, and I were evicted after my great-grandmother passed away, and we lived with her because we had nowhere else to go. We were living with her so my single mother could save money, and she ultimately used those meager funds to purchase her first home, a third-floor, small-bedroom condo with limited air conditioning facing the afternoon sun. Every penny my mother earned was either saved to buy that condo, that small condo, or used to keep the three of us barely afloat. It's something like what happened to me and my husband happened to my mom. She would have neither had the education because we barely had a high school diploma, the money or the energy to protect her assets, and the three of us would have quickly been cast into homelessness, and the trajectory of our lives would have gone in a very, very different and sad direction. That story isn't unique. Many first-time homeowners who are vulnerable are in these type of homes. All homeowners in HOAs and common owner interest communities need Minnesota Homeowners Bill of Rights, regardless of whether they're a first-time homeowner, a new Minnesotan or new to our country, a senior, or the average Minnesotan next door. I encourage you to join in a bipartisan manner to reform 515B and 317A to provide basic protections to homeowners, to protect the 1.56 million Minnesotans in these associations across the great state of Minnesota who need your help in a basic set of protections, a level playing field, basic fairness, and housing security. And I thank you very much for your time.
Thank you, Jordan. I do want to specify in the spirit of transparency that Ms. Djordan is also the commissioner of Three Rivers Park District, who does a fabulous job on that role. She is also a constituent of mine. So again, I want to be 100% transparent and make that clear. And there was a reference earlier to a very egregious practice where most of the residents were elderly. I cannot say for certain if that was from one of my constituents, but I can say that a similar situation did occur in my district. So I just also want to be transparent to the public about all of those things as we go forward and be respectful of each other. Thank you for that. We are going to go to our second presenter, and then we have some time for questions for both of you after that. If you'd like to stick around, I would be very grateful for that. You're welcome to stay where you are. I think we have plenty of seats. And our next presenter, I believe, is actually online. Mr. Hamza?
Yes.
Right?
Yep.
Okay.
Can everybody hear me okay?
Yes.
Okay. I first would like to also say that Jennifer Djordan's pretty great. Okay,
state your name for the record. If you have an affiliate
Jack
or a
Tomzak
membership organization, please state that for the record.
Okay. Jack Tomzak. I am here as somebody who's a member of an HOA. I'm not representing anybody but myself. I'm not part of an organization, just me. In 2019, I bought a townhome. In 2021, I installed a swing and a tree in my front yard, and everybody loved it. In 2022, I got a warning. I moved my swing to the backyard, and I got a warning from the HOA that was against the rules. I appealed to the board, and they agreed to table the issue, my swings, and let me keep my swings up until they could plant grass in my backyard under the swing. A year passes, my kids enjoy the swing. The board changes over, only one person remained from the board that had tabled my issue. Our management company, Sharper Management, had swapped out their employee, so it was a different person there. So he didn't remember anything. So in 2022, I started getting fines for my swing. And I went to the board and I said, well, could you get rid of the fines? Because I had an agreement with the board that I could keep my swings up until grass was planted. And it was an in-person board meeting at a restaurant in Plymouth. And the Sharper Management employee told me, because I couldn't find the minutes from that meeting from a year prior, told me that the minutes were available online. He had looked at them and there was no mention of my issue being tabled or my issue at all, or anything to do with swings or grass or me. At that point, I was asked to leave the meeting and the board deliberated and voted, and I lost. Later that week, I asked the Sharper Management employee to send me a link to the minutes that I could not find online that he said were online and that the board used to make their decision. It took a few weeks, but he admitted that the minutes were not, in fact, online or publicly available, which I think they're required to do to have the minutes. It had been a year at that point to have the minutes available to the members of the association. Weeks and weeks and weeks passed. They finally found the minutes, and sure enough, there was a mention of my grass being tabled, or the swings being tabled, but no mention of the grass. Went back to the HOA and I said, now that we found the minutes that clearly say the issue has been tabled, and if it's tabled, you can't take any action on it. They didn't care. They voted again, and I lost. Now, compared to everybody else's stories, my few $100 lost in fines and the time spent with dealing with this is minor. But if you're paycheck to paycheck, a couple $100 gone that you didn't expect is not good. Not good at all. And it was difficult and it was a pain. And now my children dislike HOAs a great deal. But the Sharper Management guy essentially convinced the board that I was lying based off of his own lie. And once the minutes were found for this meeting and it was proved I was right, it didn't matter. And what do I do? What do I do? And from the sound of everybody else, I go broke trying to be right. I bought an old car, a 66 Mustang, sat in my driveway for a day and it had expired tabs from the previous owner. I got nicked for that. I sold something on Facebook Marketplace. It sat on my step for the morning before somebody picked it up and I got dinged for that. I think HOAs can be unreasonable and there's no recourse for the people who are paying the bills. If my HOA doesn't provide anything anyway, and it's very frustrating to be living under that. So I'm going to stop living under that, hopefully as soon as next year. That's all I got, I think. Thank you.
Thank you, Mr.
Oh,
Tom. Yeah.
I don't, some boards meet in person, some meet over Zoom. It'd be great if they met over Zoom and those meetings were recorded. That's what I would like. And for them not to be able to take my house away. Okay, now I'm done. Thank you.
Very good. With that, do we have any questions from the members for our presenters today? Yes. Mr. Zabotsky. I'll get it, I promise.
I don't have a question, but I do have a point of clarity around licensure. It's been mentioned a few times that there's no licensure requirement at the last session in this session. There isn't on individual managers. You are accurate. Some other states do have that. We can provide guidance to the legislative body if they were looking to bring up some sort of licensure for people actually performing the management services. The management company itself does have to cover carry a Minnesota broker's license to the state of Minnesota Department of Commerce. Now, I do not believe there's anybody sitting at the Department of Commerce monitoring this or making sure that they are active. So I did want to provide that point of clarity that there is a licensure requirement for the management company itself. Could there be more? Most likely.
Madam Chair.
Okay. All right, sorry, just a logistical note, for those who may be on the online Zoom. It appears that we have a technical concern, in which, there is a scheduled update that is required to happen before we end the meeting. And so we may lose some folks online when that happens. My apologies there. Don't want to take my teeth to get it back up. Okay, well, in 8 minutes, we may lose some folks, so I just want to level set that. Our sincere apologies for that. We'll try to seek out another solution in the next 8 minutes, but for the moment, I just want to make sure that we are not intending to drop any participants here or be unfair. Okay. Okay. It'll still be recorded. All right, very good. You will still have recordings. Very good. I appreciate that. And then with that said, we were going to comment, and I'm sorry, I have lost track of who was next on the list. I know we have Member Cole that had a question, Miss
Yes.
Desjardins.
And mine was a direct plaintiff. So if I understand you correctly, the management company itself has a licensure through the Commerce Department, but the managers of the associations themselves as individuals do not.
Correct. So the management company is required to carry a broker's license from the Minnesota Department of Commerce through the real estate division. Managers, many professional management companies do require different certifications through community associations, institutes, or other methods. But you are correct. There's not a real estate licensure requirement. I do know that other states have a specific licensure requirement for people who operate in this area. From the manager perspective, Florida does, Illinois does, I'm sure.
So my comment is specifically towards that, because if the specific manager has a licensure requirement, they're also required to have a code of ethics. Or if they violate that code of ethics, like an attorney or an accountant, etc., you could file a business complaint, you could do something. If you're just filing a complaint against, let's just say, I don't know, gas and management company, just because they've been news recently, well, good luck, okay? Because they have errors and omissions insurance policy, and then you're in the weave of wherever. And when people have to have licensure, they tend to, let's just say, have a little bit of a duty for their own self-interest as well. So that's my comment specifically towards that.
Mr. Zavadsky.
Madam Chair, I do not disagree with you. I'd like to be clear on that. I would also like to be clear on the fact that I agree with other commentary made around the homeowner rights and also around homeowner and work education. I think that that's critical that people understand operating within an HOA, both from a board perspective, but also from a homeowner perspective, because through not in your testimony, but in prior testimonies, we had heard some inaccuracies that I would love to be able to clear up at some point. But from a homeowner perspective too, clearly understanding what it means to live in an HOA with any modifications that the legislative body makes. And protection for property management people as well. I'm going to throw that in here now, just because people in the industry work, even though they're not licensed, have been doxxed. People have shown up at houses, they have been shot at just for simply doing their job. Managers in this industry are just going to work every day, and they are trying to adhere to the policies of both the company they work for, but also trying to adhere to the governance of the HOA. And in doing their work, there have been some very severe people have been killed in this industry for simply being a company. So I would like to make note of that.
noted. I do think we also need to be aware that, we're living in very complex times, and we have seen, unfortunately, dispute resolution rise to some pretty passionate levels. And I think one of the things that has come out through this discussion is that for the most part, many consumers feel that they really don't have good paths for dispute resolution. And I'm sure that that certainly ratchets up that tension that exists between property management companies and their employees and homeowners individually. And that is why we are here, right? Because we need to find a path that is more acceptable, that is more workable, and that takes into consideration the needs of all parties concerned, and to hopefully bring down that temperature for all folks, and give folks actual resolution. Because it's clear that from this conversation that it is not happening as it should. And we need to be mindful of that. And hopefully we will come out of this process with some really solid recommendations on how to do that appropriately. And with that, Ms. Cole has come.
Thank you, and I do appreciate that the Department of Commerce does have that license, but the broker's license is only regarding sales. If the person is involved in sales or rental property, then yes, but there is no licensing, for example, when First Service is a sole signer on our $1.8 million reserve account, there is no oversight, there is no requirement, there is nothing that puts them in place of any kind of accountability for those types of functions. So if the person, the licensing is only is around sales, if they're selling property or managing rental property. So, but we need to have that discussion about what is the role and where the accountability are with that. And I also want to say around the board members, we talk a lot about voting in board members. Our board members haven't been voted in. Our board chair has been appointed by First Service, and there is no record of our board being voted in, but it is the board chair who signs their contract. And so this all goes back to the roles and responsibilities and defining those relationships. And we haven't had a annual meeting in 3 years, and our CCR say the board members are supposed to be voted in. But when I ask for records of the vote, then I get that letter from the attorney telling me that I can't ask questions and I can't go to the board. I'm prohibited from talking to the board. So we need more of a definition. We need more of the accountability of roles and responsibilities. Because if the association, their purpose is to enforce the CCR, then they don't work for us. Their accountability, that by direct line, if you want to follow it, is if they're enforcing the CCR, they're not representing the homeowner. So why are we voting in or even messing with the board that is responsible, is supposed to be responsible to somebody else? So that's a huge thing in all of this, is defining.
They didn't do what their job description, for a lack of a better word, but they're supposed to.
Thank you, Ms. Bull. I do think transparency is definitely a theme that we've also seen throughout this conversation. And we certainly need more of it, which is again why we are here. Mr. Zavodsky.
We are going to make actionable changes, which I believe they're. I've been in this industry for close to 20 years. I do believe that it's growing to a point where we do need to make actual change. But facts matter. And when I'm speaking about facts, what was just stated is not a fact. There has been an annual meeting at that particular association. In fact, it just occurred. You ran for the board. Ms. Cole ran for the board. She received 2 votes out of 280 homeowners. we're going to call out people and call out facts, I believe that that's important. I'm more than happy to supply that information in a future forum as public record. But I do want to make sure that as we're discussing policy and as we're moving through this, that facts are important. They're important to make the right decision moving forward to protect homeowners and to protect both consumers, to protect people who work in this industry. This industry employs tens of thousands of people. On top of that, it's also meant to protect, like I said, homeowners, people who work in the industry. We have to think of builders as well, so that the appropriate legislation is put in place so that the right actions are taken place so that we have that diverse set of housing that's available out there. We have to think of the entire picture. And I would just like to say that that is not an accurate statement that was just made. And I would like that on the record.
And the record.
Thank you, Mr. Zavadski. Please remember to go through the chair.
Thank you.
I will certainly allow you to make a follow-up, Ms. Cole, but I do want to remind members that we want to be respectful of all folks, make sure to avoid talking in generalities here, and be thoughtful and polite to one another. Ms. Cole, if you'd like to follow up.
Our board chair has never been on a ballot. When I asked why the board chair has never been on a ballot, I have been referred to the attorney and told by the attorney I'm not allowed to ask questions. So how does our board chair get to be on the ballot, and how does First Service get to be on the Secretary of State's registration as the president of the association when that hasn't been voted in? So yeah, okay, I'll agree. There was a annual meeting the first time in 3 years. We hadn't had one before that, and so when the rules aren't followed, or what do we do as homeowners when somebody else is making up the rules? And why do we have a board chair who we didn't vote for? And there is no evidence. I asked for evidence of the board chair being voted in, and they can't provide it. He wasn't on the ballot, but he's continuing to be our board chair. So how did that happen? Where did that happen? And that should be part of the business record of how that happened, and they can't provide it. So yeah, that is all part of the operational transparency, and yet here we are with that. And all of the board members have been appointed. And I understand when the association is first initiated by the builder does typically appoints the first set of board members, but we are way beyond that, and that we should be voting in and not having the board members be appointed by somebody else who is supposed to be a neutral third party.
Okay. Thank you, Ms. Cole. I just we do have, I think, a couple folks on the list, and I will ask Mr. George to reiterate that. But I do want to remind us that the intent of this section of the agenda is to make sure we're asking questions of the presenters, if they have any, because we do not often get their expertise here. And so we want to make sure that we are making the maximum amount of use of their efforts and expertise and getting those questions asked while we're here. And I know Ms. Djordan has come quite a ways to come, and I appreciate her being there, as well as Mr. Tomzak. And I do think the senator has a question as well.
I have a question, but I can wait till the end.
Okay.
Recording in progress.
Hold on. Mr. George, if you could direct us who is next on the list and who is on deck.
I believe it's Ms. Taylor. I saw your hand was raised.
Okay. And who do we have? Who else is on the list?
And then no one else was on the list.
Okay. All right, if there's other folks that would like to be on the list, sort of make sure to get the attention of Mr. George here, and he'll make sure to add you to the list. Then we will go on the Zoom to Ms. Taylor.
Yes, I had a related comment to the conversation. So if you wanted to move to questions, instead of comments, then that's why I put my hand down.
All right, very good. Well, we will pass you for just a moment, Ms. Taylor.
I'm sorry, Madam Chair, I did have a question.
I'm sorry, we missed your name there.
Sorry.
Butler?
Yes.
Member Butler, please, go ahead.
I wanted to refer back to the question I think the senator asked around dissolving or removing HOAs from the property. Are we saying that we don't know that it's happened before? Or if it has happened, can we say where it has happened?
All right.
Because I believe it has happened, but I just wanted more clarity around that.
We may have an answer in the room, Ms. Djordan.
Madam Chair, and members, it's very, very almost impossible to dissolve an HOA. The reason is because not only do you have to get consent of, you're correct, like a vast majority, if not all of the homeowners, you also have to get consent of the mortgage holders, like Wells Fargo, et cetera, et cetera. So good luck with that. And I mean, these things are embedded deep into the property at the time of inception. So to dissolve one is nearly impossible. Even the documents themselves at the time of construction by the developers are flawed. Ours wasn't, maybe we went on an exhaustive Where's Waldo hunt for the documents under ours, and the association didn't have it, and we finally found them. They weren't even signed, and you can't even get them off. So what happens is that these developers put them on, they take off after they get to a certain percentage of completion on terms of the developed property. Cities love them because it takes over like a development of a piece of property. They're stuck on there, and it's like it's sticky. It's too sticky to get off. I mean, so unless there was created a legislative off ramp under the current construction, it's nearly impossible.
And then I think I will just want to make sure, Ms. Butler, did that answer your question, or do we have anyone else that had a response for Ms. Butler? Okay, in the back, I'm sorry, Joni.
Yes.
All right.
In hours, it is 67%. The state of Minnesota TV also has a default of 8%. So, but unfortunately, as you can see, we had a petition, we had presented, they denied, they ignored. And so we ended up, getting all of the consent of owners, as well as even affidavits saying we didn't let them. They're all notarized and stuff. But the issue is them following the rules a lot. They don't do that.
I appreciate that input. All right, Ms. Butler, I'm sorry, you chimed in. I didn't know if you had a follow-up or question.
I have a follow-up. You say that the city is requiring, do city make money off the HOA? Is there some dollars or economic value that is provided to the cities, the municipalities that require the HOAs to be put in place?
I think Mr. Elwood or Ms. Gugin. Yeah. Just to be clear, I know that we kind of had an earlier testimony that cities may benefit by deferring some of the costs for infrastructure and things like that. They may not necessarily directly benefit financially from it, but they certainly would potentially have the savings in some of those infrastructure costs that might be deferred to the association. Ms. Berger.
Yeah, I can just share what I'm aware of the situations where cities may be requiring the associations is when there's a common space that doesn't have if the HOA owns common space, or if there's a common space that everybody shares, somebody has to control that. And so that's where the HOA would come into play. But I'm not aware of cities that are requiring it. It's usually what the development is, the developers are wanting to create this type of scenario, and so then they would need somebody to be responsible for that space. So that's how I understand it, but I would be happy to talk to some colleagues in other cities to find out if there's actual requirements in place. I'm not aware of them.
Yeah, I will say, just as an aside, I have heard of a number of situations in which cities did require that. And so, I just want to be clear on that, that there are places in which that is the case.
Yeah, I wouldn't assume that to be true if there's a space that somebody has to own. If it's a commonly owned space, there has to be somebody or an entity that. So yeah, I'm not saying that they wouldn't say that we were required. It just would be not, because of the type of development that's being done.
Understood. All right, thank you, Ms. Berggren. Okay, with that, I think we've addressed a particular issue. Senator Lucero, do you
Thank
have
you.
a comment on that?
Thank you, Madam Chair. I do have a question for Mr. Djordan, but to address this specifically.
Yes.
So last session, I had a bill that dealt with a number of things, and among them, my bill had a proposal that said municipalities cannot have requirements that would necessitate the formation of an HOA. And so in developer agreements, what is happening is a developer will come forward with a proposal and they want to have whatever the development would look like. The city, upon agreement of that, or a condition to agreeing to the development agreement, is that the developer will put a park in there here, and the park will be controlled by an HOA rather than the city, or whatever other amenities, a pool or whatever. And so that's how it's happening, is the municipalities are requiring amenities that necessitate an HOA. And if they don't do it, they won't get an approval. And so it's kind of strong arming developers into forcing these HOAs, which is resulting in 82% of homes now being in an HOA. So the question, I have two questions. First question to Mr. Djordan. The bill or the homeowners bill of right proposal here, is this patterned after other states then, or did you develop this yourself, or is there something we can point to?
So Madam Chair, Senator Sarah, it is a combination of research that myself and my husband have done of what other states have done and what other states have been successful in passage. For example, Texas did a whole slew of reforms, as well as, like I said, Colorado, California, Florida, and a few other states. And understanding just from talking to fellow homeowners and doing research on Minnesota, where our gaps are and where we've fallen behind other states that have reformed in a reasonable way. And I don't think anyone's proposing, not doing things that are too crazy or too radical, or doesn't find that proper balance between, yes, obviously there are homeowners associations, yes, there are common things and there may be comments. But because no one anticipated these large classes of property, single family homes, townhomes, condos, senior active living communities, etc., all shoehorning into a set of laws that weren't intended for that. And as my husband has noted in the past, that these cities, it's convenient for them to hand over control of development of a certain area and come in as a package. We've created these gaps in donut holes. And unfortunately, homeowners and people are stuck in the middle, and the documents are not written in clear and plain language. And here's where we are. So it was just a reasonable set or something. I didn't know if you all had gotten that far yet, but I thought it's easier to talk from something than from nothing. And we just didn't want to come with just complaints. We wanted to come with some ideas for everyone.
Senator.
Thank you, Madam Chair, and I appreciate that, not coming to just talk and complain, but to have solutions. And I deeply appreciate you compiling this, and I'm going to hang on to this as these discussions and this work group ensue. Then my last question, Madam Chair, is a point that came out as part of the conversation that took place. Several people spoke about it. I completely agree. As starting out as a real estate agent license and then as a broker license, everything geared in the learning and in the continuing ed, it's all focused on sales. It's all focused on agency. And I'm just trying to think in my mind here, is there anything that I've ever heard on property management, HOAs, and any of my continuing ed over the years? And nothing jumps out at me, but clearly the focus is on agency when it comes to buying and selling of real estate. So the question of clarification, did I hear, I don't remember who said it, that there are other states that specifically carve out a property management license, not blending together a real estate? If I could just, whoever said that, if I could get clarification.
It's me,
Okay.
but I want to go to the chair.
I'm sorry, Mr. Zabadsky.
Thank you for the question, Senator. Yes, there are other states that we could mimic and look at around licensure requirements related specifically to HOA management. I think that the way the Minnesota statute, how it grew up, is that they just didn't know where to put this, honestly, when HOA started becoming a thing, and they just threw it in the Department of Commerce under real estate.
Okay, thank you.
All right, I do want to make a quick clarification. I will give you just a second. I do want to make a clarification that we are actually at 12 noon, which is the scheduled end time of this. We do still have a number of folks on the list. I am more than happy to stay and to hear those comments. But I do want to be kind and make sure that we respect people's time. There may be some individuals who if you are one of those individuals, I ask that you please try to do so quietly and orderly. But I will be happy to remain so that we can get through the additional folks that are on the list so that they have time to weigh in. And again, I want to make sure that if you do need to leave, you are aware that you can. It is 12 noon, so I want to be respectful of that and folks' time. Where there's one comment on the end, and I'm sorry, I do not have a placard. Ma'am, do you want to? You got a comment? I'm sorry,
I can't hear. I'm Carla, and I live in South Maplewood, and I live in an HOA. And I'm also chair of All Elders United for Justice, which is why I'm here. But what I'd like to know is, does anybody know or have records on how many seniors live in HOAs? That might be in the US Census, I don't know, but that would be my question.
So my apologies, we did not realize, I thought that was relating to the last conversation, but certainly we moved to a different topic. Do we have someone who's,
I'll speak to the elder question. No, I don't, but Todd had a response to the league's question regarding reserves and cities.
Okay, all right, let's put, do you have a question on the elders? All right, let's go ahead, Mr. Zabadsky, to speak to the elder question, and then we'll circle back.
I could try to find that information. Through CAI National, I'm sure that they have stats around demographics. I could certainly inquire.
All right, Mr. Elwood, did you have?
Just quickly, we don't have statistics. There are no statistics, I don't believe, or there might be, but we don't have. What I can tell you is that the clients that come to legal aid with complaints and concerns and disputes and issues are predominantly elders.
That is a good call out. I appreciate that, Mr. Elwood. Okay, so I think the answer to that particular issue is that we do not have statistics. We know that there are a disproportionate number of elders that do have concerns. And Mr. Zabadsky is going to try to dig in and see if he can find any statistics on that. Ms. Fuller, your comment specific to this item?
Yeah.
Go ahead.
Department of Human Rights doesn't consider age to be a protected class as far as they are concerned. So there probably isn't going to be statistics around elders.
Yeah. All right. Very good. Thank you. And thank you for that. With that, I do want to keep us moving. We did have a clarification. Mr. Djordan?
Madam Chair, just a comment on the question about replacement reserves that was raised earlier.
Yes.
I sort of know that's what they're called in governing documents and so on. But homeowners associations are required to maintain adequate replacement reserves. They usually defined in their governing documents or which section of law you're under is defined there. However, in many cases, and our homeowners association included, they don't follow that. They don't maintain a separate reserve account for replacement reserves. And as it was referenced earlier, they just fund through, as needed assessments. In our homeowners association, and it's reflected in some of the documentation we provided, I asked a question in the open forum about the reserves for our homeowners association. I was threatened with a fine of $50 for asking that question. They have not provided any information on reserves and claim they don't have a requirement to maintain reserves, which is correct. If I wanted to correct that, we're going to report all the things that happened as a result of that. So, and I was threatened with $50 fine even for speaking and asking a question in the.
Yeah, and I think it seems that it would be a reasonable question as you are paying in dues that are a portion of which are supposed to be going into reserves to inquire about those reserves. That seems like a reasonable question. And again, we are here because sometimes we are not getting very reasonable answers, and I think that is a good call out. Mr. Savatsky, did you have a brief comment before we move to the next item?
No, I didn't, but I can comment on the reserve piece just briefly.
Yes, go ahead.
I think it's important to note that this is really important for us to consider. Not all HOAs are required to follow CICHOA, which is the governing body, the 515B. Some HOAs are excluded, particularly usually single family communities. So in my opinion, they're in this weird hole, as you stated, a donut hole, I think with your reference of how do you govern them? Because they're not part of CICHOA, but they're still an HOA, so they still have governing documents. So I think that's important to know for us as we consider moving forward.
Good. Thank you for that. With that, I want to move on to the next person on our list. We have Ms. Borden online.
Hi, yes, I raised my hand when there was conversation regarding the dissolution of associations. I do have some experience and feedback on that if you want to discuss it further. Otherwise, I don't need to say anything.
Go ahead, Ms. Borden.
In my experience as managing HOAs over the last 26 years, I've had 2 clients that have actually dissolved. They were single family home associations. One was several years ago, and for the life of me, I can't remember. It was up north. I can't remember the exact city, but most recently, it was an association in Ramsey. It was a single family home that was under the umbrella of a master association, and then a sub-association along with them was a townhome community. The single family home wanted to dissolve from being in an association and dissolve from being under the umbrella of the master. The master association, separate entity, only responsible for a playground and a gazebo that was split between the properties. And the single family home association worked with the attorney. The townhome community was involved as well. It has been going on about 3 years. And yes, there's language in the governing documents that do allow for dissolving, but it is a rather lengthy process. This association had to get 100% of the owners and 100% of the mortgagees. And they were able to do that over several voting opportunities, and then work with the city on splitting the responsibility of the playground. And the city did agree to take back the playground to make it a community playground. And then the townhome community took over the common property that the gazebo was on. So there were a lot of logistics, the attorneys being involved and the city being involved. but they were able to get it accomplished, and they're just finalizing the actual reserves when you're speaking of reserves, because reserves had to be put aside on the single family association books and on the townhome books for the future repairs and replacement of the gazebo and the playground equipment. So once the city took back the playground and once the townhome community took ownership of the gazebo, then the funds had to be audited to determine of the reserve funds which belonged to the single family homes and then split equally back to those owners for no longer having to contribute to the playground or the gazebo. So it can be done, but a lot of parties have to be involved. And with regard to the municipalities being involved from that developer level before the associations are even built, yes, Senator Lucerno touched on the topic. It does have to do with shared amenities that the cities or the municipalities do not want to take financial responsibility over. And it can be not even a shared amenity, it could be a street that the city does not want to take the ownership of and the responsibility of maintaining and snow removal and that. The property taxes also come into play. And part of zoning from a corporation perspective, of which an association is deemed a corporation, they're zoned and there's property tax implications. So yes, there is a financial gain on the municipality side from stating that you do have to form an association because the property taxes can be billed at a higher rate. But I do think to get a good understanding of why the municipalities and cities do have a part in determining whether it has to be an association or not, we should have someone from the developer side of the business or an attorney speak on the legalities of that.
I do want to make so have Mr. Hanson on the list, Ms. Taylor on the list, and Ms. Nichols on the list, still to speak. So I just want to be aware that we have those three. I know a few folks in the room are starting to leave. So I just want to throw out there, Ms. Taylor, Mr. Hanson, and Ms. Nichols, are any of your specific questions to the speakers or presenters today? Okay, then let's go with Mr. Hanson first. And of course, I will stay here for all of those comments, but I want to make sure that for those folks who presented, that those get addressed quickly. Mr. Hanson.
Appreciate it, Madam Chair. Mr. Tomzak.
Mr. Tomzak? Still have you here? We need one.
Okay, Madam Chair, my question was directly related to Tomzak, so.
Okay, my apologies for that. We can certainly, if you want to submit that to the staff, we can follow up with him to make sure that answers get addressed on that particular issue. Then we have Ms. Taylor, I believe on Zoom.
Yes, thank you, Madam Chair. One of the things related to the current conversation that I was wondering, is there an ability for our research staff to dig up some of the examples of language of where municipalities are requiring these HOA formations through the development agreements? I think that would be interesting information for us to see those examples. So that's an ask for me as a member in terms of informing the work that we're doing. In terms of the previous conversations around property management, licensure, and accountability, I really want to uplift moving forward with a solution around that to give you some examples around where our property management has not been accountable and where I think the egregious power imbalances. When we are not accountable as homeowners, we can get fines, we can get things levied against us, we can lose our homes. Nothing happens when property management doesn't do their job correctly. And so So one of the things that happened recently, I was out or not attending just 2 months of meetings of our board because I had surgery. It's why I missed the first meeting here as well. So when I went back to read the notes, I saw that there was a magical new 6th board member that had been elected by the board as a non-voting board member in service of the board that the board elected to serve the treasurer. And I inquired about what were they doing? What is going on? This is against the law. Here's the statute. And they were like, well, we were told we could do this by Associa, the property management. And I was like, you cannot. It directly contradicts the law. Board members are elected by members at the annual meeting. So they looked into it. They saw I was right. This person was unelected from the illegal election on the board. But then the board developed a finance committee that they made them the chair of, and then made all membership to the committee be somebody with accounting experience. So they just then loopholed having this person not be elected by members and put them in another position of power that nobody could really actually join that committee then, because not everybody has accounting experience. And so that was led and it told was accurate by our property management. The other thing that happened within the last year was we received a very large assessment, a little bit out of nowhere for our roof, which also had a 1/3 contingency for the project attached to it, with the decision, and this is in Minnesota law, that boards may decide to either return the money or put it in the reserve. So they had a 33% contingency for the project. So the roof was done. Obviously, they did not use that massive amount of contingency. So they then put $90,000 of our special assessment into the reserve, which law does state you cannot fill reserves using special assessments. So I think there needs to be law around not allowing for extra funds that are unused during assessments to be put into reserves. They do need to be returned to homeowners, because I think that is a loophole in allowing people to use special assessments to fill reserves, which is not allowed under the law. And in that situation, my building is predominantly seniors. We had a lot of people that could not meet those assessment costs between, depending on unit size, $3,000. I paid $5,200 for a 2-bedroom to like $8,000. They gave them 6 months, no payment plans. And Associa came to, uplift how people had to pay their bills. And I pointed out to Associa that on their own website, they had a list of best practices around doing special assessments. They had not advised our board nor followed any of them. They did not have special meetings. They did not offer payment plans. They did not do any of the best practices. So I'm bringing this up to say, I think it's very important that property management has licensure requirements. I think it's very important that the services they are providing to us are aligned with best practices and are ethical. We have not been, they are completely in service to the board. They are not in service to the homeowners, which has been an issue that we have had. And they're not even following best practices of the industry, nor advising our board to do so, and are actually advising them to do illegal things. And all we get then is an oopsie. And there is no recourse for us unless the board decides to fire them, which generally they're working very closely, and that's not going to happen. So that's kind of what I wanted to uplift around our conversations today. In terms of the assessment, we had a large number of people be displaced because of that assessment, seniors that had lived here for decades. And when brought those issues to the board, like, hey, we agree the roof needs to be fixed. We really want to talk about how we could pay for it. The board said things like, we'll pray for you. Lots of people can't afford different types of housing. There's lots of places I can't afford to live. Hey, here's a financial budgeting workshop I found at AARP that might help you. You can't budget your way out of a fixed income. So some of the callousness coming out of the board members was really problematic, and that's just some of the stuff that is happening every day across the state.
Thank you for that, Ms. Taylor. I do want to make note and an apology. We did have Ms. Nichols on the list as well. Unfortunately, Ms. Nichols had to leave. So I want to send a sincere apology that we ran a little long on questions and we did not get to her question. If we're able to get to her, we will certainly try to follow up on any questions, comments from her as well. And certainly Ms. Nichols, if you are seeing this, hearing this, please reach out to Mr. George. Again, that's Andrew.George at LCC at lcc.mn.gov. Please reach out and bring that forward. And we'd be happy to follow up with you. My sincere apologies. We did run a little bit over. We are about 20 minutes overdue. With that, I am going to move to actually adjourn today's session. But Mr. Hanson, you had a question before?
Yeah, just a comment, Madam Chair, I would like to encourage possible when it comes to publicly posting agenda items, board packets, etc. Have a big value here to the 3-day rule. I know the agenda was posted until I believe yesterday and at least Wednesday. So just for the public, that would be very helpful. Yeah, thanks.
Well, and I will also apologize. I suspect that part of that may be that staff was waiting for approval from myself and the chair. So I will apologize to everyone for that. That may have been us. Some folks may be aware we're in a very hotly contested election season for at least the next 11 days. And so our resources are a little bit divided.
Don't worry.
Hopefully things will get better in 11 days. And both I and the senator will be a little bit more responsive. So my apologies on that. We will do our level best to be more responsive to the staff questions. I know they do their best to get those answers from us. And with that, I am going to go ahead and call this session of the Work Group on Common Interest Communities and Homeowners Association adjourned.
Do you have any questions?